The essence. I'm Sandy Weinberg. I actually was the chair of the criminal justice section last year, and have been involved in the ABA for a long time, since this is my 43rd year of practice. I am currently with Zuckerman Spader and have been for a long time now. I practice because I happen to live in Tampa, Florida, so I practice out of Florida, but we're an East Coast-based firm, mainly doing white-collar criminal defense work and high-end civil complex litigation. And a long time ago, in my youth, I was in the Southern District of New York as an assistant U.S. attorney doing Wall Street cases. So today we're going to talk about something that Lisa touched on, and that Bill touched on, but I call it prying eyes. Think confidential and privileged client information is safe at the border or in cross-border investigations. Think again. The ethical and legal challenges for international lawyers and their clients, and of increased border searches and other challenges, and there really is an incredible challenge that we all face when we leave our countries and we go across the border as it relates to attorney-client privilege. And so today we're going to focus on what I would call some of the assault on the privilege, and we're going to talk about, among other things, what happened in Germany in the last year and a half or 2 years in the Volkswagen investigation, and actually other investigations where German prosecutors have actually searched law firms, not law firms that are involved in criminal conduct, but law firms that are doing their job. And the most high profile of those searches was a search of the Jones Day offices in Munich, and we have the honor today of having one of the Jones Day lawyers. So let me introduce one of our panel members is Jim Woolley. Just raise up your hand. Jim has the distinction of being a very prominent lawyer at a firm that has been searched several times now.
Everybody else here is because of some specific achievement or success. I'm here because I got my firm rated.
Yes.
But I show up when Sandy asks me. He's like the lemon in my paper cut. I mean, whenever he asks me to show up somewhere.
So among other things, Jim is a white-collar criminal defense lawyer who spent a large part of his career in the Justice Department. So he has a wide range of doing international cases. On Jim's right is Harsh Trivedi. Harsh, another American that has chosen to live in and practice in England. He is now the managing director of J.P. Morgan's legal department, co-heading the global government investigations and regulatory enforcement. In other words, he's in charge globally of all these investigations that touch J.P. Morgan. So he really will give us a sense of what it's like to be, in a corporate legal department facing these challenges. On Jim's left is our UK lawyer or barrister, Simon McKay. Simon is really one of the leading, and where I was put onto him, is one of the leading civil liberties and human rights law practitioners in the UK, well known in the United States, and with a real focus on national security law, including terrorism, covert policing, police powers, and technology. And he can give, and he will weigh in today, from a private practitioner's point again in the UK as to some of the ethical considerations that we face when we are facing issues with regard to our protection of the attorney-client privilege. And on Simon's left is Holly Lasso. Holly is a partner, litigation partner and member of the Weil Gotshal firm's global white-collar defense and regulatory investigation practice. And Holly is involved in a number of cross-border cases, and Holly's firm, I don't think, has been raided yet. So she can explain how they have 3 offices in Germany and have avoided that. And then my friend here, Bjorn Gerke. Bjorn is a German lawyer who has the challenge of explaining what the hell is going on in Germany. But we have worked together for the past over a year now, representing a high-level executive in the VW investigation that Jim is going to talk to you about, and have had the experience of having our attorney-client material seized by a separate search of a client, but nevertheless a problem. So why don't we get started by discussing the ramifications of the March 2017 search of the Jones Day offices in Munich, arising from the so-called Dieselgate investigation of Volkswagen. So first I'm going to have Jim Woolley describe the search and generally what was seized, and then I'll because they still have, in light of the fact that they still have dealings with the prosecutors with regard to this, there are some things that Jim can or cannot say. So Jim, I'm going to ask you to sort of put this in context for us, and then I'm going to ask Bjorn to address sort of the legal side of the Jones Day search and try to explain what the state of the privilege is in Germany, which is just extraordinarily different than what we have in the United States or even in the UK and maybe other countries. So Jim, why don't you start by telling us about this search and what the role of the firm was and what happened basically, what was taken.
So we were hired by the supervisory board of Volkswagen to conduct an internal investigation of the diesel issues, and both at Volkswagen and at Audi. And Volkswagen, the supervisory board, had a very specific reason for being interested in Audi. It's a wholly owned subsidiary, and Audi made the 3-liter engines that were in Volkswagen cars as well. Volkswagen made the 2-liter engines. So we were hired to do this internal investigation and to cooperate with whoever our client directed us to share information with. It was pretty standard stuff for American practitioners. We were going to do a privileged confidential investigation and then share things at the direction of our client with the authorities that were looking at it. The problems with the diesel engines had already been sort of acknowledged. So we were on a path to sort of figure out exactly what happened and who was involved. It was a very meaty investigation. We did probably 700 interviews. A fascinating, interesting case to be involved in. It rolled off the tongue easy to tell your friends you were doing it until they raided our office, and then that became a little bit of a pivot in terms of the enjoyment factor.
So, when they came into the office, what did they tell us about? What did the search warrant allow them to do, and what did they take?
Yeah,
basically?
so it's a raid in every sense of the word. It's a dawn raid. Police, prosecutors showing up at our office in Munich. And the warrant itself, and I'll just read from it. It makes very clear and lays bare that they're not looking to see if maybe there's some original evidence that's been squirreled away in our office and that we've somehow been complicit in something. And there was never any suggestion of that. But they just want what we all would consider as U.S. practitioners our work files. They want items, specifically documents assembled or created by the Jones Day law firm in connection with its internal investigation commissioned by the supervisory board. Specifically documents related to interviews of employees at Audi AG, correspondence and presentations by Audi AG gathered by Jones Day, correspondence between the Jones Day law firm and Audi AG, especially the representatives of the supervisory board, remarks, notes in connection with the assignment, and the final report or any drafts available created by Jones Day. So basically our files is what they want. And they came in and took 185 binders and then seized electronic data as well.
And did they have a taint team or anything like that? I mean, was there any sort of communication with them during the search? Guys, this is privilege. You're going to be tainted. What the heck are you doing?
We without getting into exactly what people said, people voiced the appropriate, objections there on our, but they did not have what we would know to be a taint team, Sandy, as in the United States. We sought immediate sort of provisional relief that they shouldn't be able to look at things until the case worked its way through the court systems, but we had to seek that relief from the court, and we were able to get that until it worked, and then it worked its way through the court system.
And just to sort of fast forward, and Bjorn will talk about it worked its way up to the Constitutional Court, and the Constitutional Court this summer issued an opinion basically sustaining the search, although Bjorn will. But were y'all searched again?
Yeah, and thank you for bringing that up.
Wait, who is it?
Jeez, mother. Yeah. When we lost, we came in second in our challenge at the Constitutional Court. It was a solid second, I think. There was a raid then executed the day that decision came down as well.
They wanted to make sure they had everything.
Yeah, apparently they had so much fun the first time. They just said, we've got to go do this again. So
basically, what they took was the entire work product from a really massive internal investigation, including what the witnesses had told you, and your analysis basically of the essence of
right.
that.
And we had been, and this is part of the record, we had been cooperating with the authorities of the United States, and we had been sharing things and cooperating with people. So we had been, at the direction of our client, been giving real-time cooperation, but they just didn't have the materials.
Well, they've complimented you on how well y'all did the investigation.
It was an interesting thing. There's no element of, and when it first happened, I had this oh my gosh moment, there's going to be some allegation of a crime fraud exception or something that we're complicit in something wrong. The opposite. The opposite. The dialogue has been, you have the best, clearest understanding of what happened. Your relationship with here was not protected by any privilege. We just want that stuff. You do not represent an accused party in a criminal proceeding, and therefore you don't have a privileged relationship which we, the prosecutors, will recognize. Here are the Munich prosecutors. Bjorn's shaking his head, but that's the core justification.
And just so it's clear, I mean, this was a massive criminal investigation that had been undertaken initially in the United States, correct? I mean, it was and at this point, had VW actually entered a
we'd
plea?
already, the company had pled and had gotten points for cooperation. And the authorities in Germany, as we understood it, were working with Ms. Moser's team from the fraud section, and we understood that there was substantial cooperation back and forth, and we believed in sharing things that they had everything, but that they wanted the actual original.
And the argument was not that you had waived the privilege. They didn't come in and said you waived the privilege, therefore we can take all the stuff.
No. They said that your relationship, you do not have a privileged relationship that we recognize. You're counsel for Volkswagen, who is not a criminal target or a criminal subject.
In Germany.
In Germany. They have no corporate criminal liability, and the individuals were the ones that were being focused on. And we were gathering facts, and they said that's not something that's protected by a privilege.
So Bjorn, tell us about this defense privilege, if there is one, in Germany, and describe the Constitutional Court decision for us. And I know when we first got involved, you tried to explain to me what the attorney-client privilege was in Germany and how one had to be an accused, and it was hard for any of us to understand it. But if you're going to do a case in Germany, you really do need to understand this, as we've come to understand.
Okay, I will try to make it simple. We have, of course, a legal privilege in Germany, but we have different classes of privilege or protection.
We have the economy class.
Yeah.
We're in the back of the plane.
So if you want to sit in the first class, you have to have an individual accused, and you have to be defense counsel. This is first class protection. This is a real strong legal privilege, as you know it from the US or the UK. So everything, as you told, depends on the relationship between the individual or the company and the lawyer. So you have a full, strong legal privilege between an individual accused person, I will tell you later what is an accused person, and a defense counsel. Then you have a second-class protection between an individual accused person, and what we call other professional secret carriers. That mean normal lawyers that are not defense counsel. There's a very important distinction between a defense counsel, criminal lawyer, and a normal lawyer.
So Harsh would be a normal lawyer, you think?
I'm a privileged lawyer.
Okay, you're privileged.
He is a normal lawyer. And he has the same privilege. A normal lawyer has the same privilege as an accountant or a tax advisor, or people like that. And then you have the third class. This is what the Court of Munich pretends to be in your case. It's a non-accused and a normal professional or any professional secret carrier. They say, and I will show you the differences between the protection. Every one of these guys, every lawyer, doesn't matter if he's a criminal lawyer or not, has the right to refuse to give evidence about that what he heard from his client. So if he talks to his client and the client tells him something, it's privilege. He does not need to talk about it. He has also, and this is a new law, he has also strong protections against any surveillance. So I can keep you cool. You don't risk as a lawyer that your phone is tapped in Germany. In every class,
Right.
in every class.
Right.
But what is important for these internal investigation, the protection of your documents or your data is only protected if you have the full legal privilege in any physical area. That means either in the physical area of the client, of the company, or in the law firm. We have the first case that was important because the fact of internal investigation is something really new in Germany. We have this perhaps since not more than 10 years. The first case, big case with internal investigation in Germany, some of you will remind, was the so-called Siemens case with a US background. This was the first time that a big German company had some strong legal problems with the US agencies, and they chose a US law firm. And that was the first time we have these internal investigations. And then 2 years later, in 2010, another famous company, law firm, Freshfields, they made a big internal investigation at a German bank, at the Bank of Hamburg, Hasa Nordbank. And there, because these Freshfields, they came from England, they have the background of the strong legal privilege in England. And then the prosecutor of Hamburg, they raided, but not the law firm itself, but the company. And then the district court says, this is okay, you can raid the company because, you remember three-class protection, they have the third or the second-class protection. That means nothing is safe in the physical area of the client. You have only things that are only safe are in the first, if you have an accused individual person and if you are a defense counsel. And at the so-called Freshfield case, Hasa Nordbank, there were neither an individual accused person because they represent the company, and there was no defense counsel because Freshfields was not acting as a defense counsel. So there's a big distinction in Germany between internal investigations and a criminal case. There are a lot of contradictions because on one side, everyone, the legislator and even the prosecutors, they like these internal investigations, they like this act of self-clarification, but on the other side, our law, we have a criminal procedure code dating from 1870, it's not made for these internal investigations. There are a lot of things that are not clear, for example, for data protection, labor law, and the fact that these results of the investigations were not protected. And we have another view with regard to what we've called an accused person, because in Germany we have no corporate criminal liability. It's only administrative law. So there can be fines against companies, but not under criminal law. So from old school view of our procedure code, a company never could be accused. So that has led to jurisdiction that is not unitary. We have a lot of different decisions of several district courts. There are district courts in Germany saying, for example, at Braunschweig, this is based for the VW case, or Mannheim, or other cities, telling that you could be seen, treated like an accused if you're a company, because time has changed. And of course, a company is touched by a criminal procedure as well as an individual. And they also said, because this was something important for our Stuttgart case that I have together with Sandy, that you could be an accused even if there's no formal procedure. But there are other courts, as Munich, as Stuttgart, or as Hamburg, telling you could only be an accused if you're an individual, and you could only be an accused if there's a formal procedure against you. In our case, for example, I think we can tell it because name it, the Stuttgart prosecutor as well as the Stuttgart district court says we have no legal privilege because at that time our client, he did not even know that he was accused. So he was accused at the day of the raid. Of course he wasn't accused, but he didn't know it before. And so our stuff, because we marked it when there were folders written on Zuckerman Spader legal privilege, Gerke Wollschläger legal privilege.
I got it about as much good as Jones Day.
They took everything and they said, no, you were not accused because this is the first day that you know that you are accused. So you could not be accused. And
so sorry to interrupt.
It was an abuse.
So tell us. So quickly, but tell us what the Constitutional Court, which is the highest court in Germany, did with regard to the Jones Day case.
They avoided to take a decision because all these questions that I mentioned a few minutes ago were not decided. They didn't say took any position with regard to the several classes of protection or legal privilege. They just said Jones Day and even the lawyers have not the right to appeal. So it was a very formal decision. They decided nothing. They said Jones Day has not the right to appeal because they are not a German or EU-based company. They have an office, I think 50 or 60 lawyers in Munich, but they said the place of, they called it effective management, the head office is in the US, it's a US-based company, and so they have no right from under the German constitution. This is, of course, in my eyes, ridiculous. It's discriminating an international law firm, and it will, if the court continues this jurisdiction, it will lead to dodgy ways, and you need an affiliate in Germany based under German law.
So
really
basically, the court said that there was no standing. Jim, your firm didn't have standing, according to the court, because y'all were an American-based firm, even though you had a large German office, right?
Yeah, we have an office in Dusseldorf, we have an office in Frankfurt, we have an office in Munich. We're all in Germany, but it's a constitutional court, and we were raising what they considered constitutional issues, and we didn't have standing as citizens of.
And the individuals didn't have standing. Why?
Because they did their work associated with us, a non-German, and they were German. They're German. They are German citizens.
And Volkswagen didn't have standing because why?
Because they said that it was a procedure against Audi. They made a distinction. They said Volkswagen was not touched by the raid, which is true because in their eyes, in a very formal view, because it was not in the rooms of Volkswagen. And they said for the confiscation of documents, because you always have to make a distinction between the raid and the confiscation, they said that Volkswagen was touched, but that the Constitution has not been violated. They didn't say that the view of Munich is the only view that is correct, but they said that at least there was no violation of the Constitution. It's important to understand for you, the Constitutional Court is not like a high court. It only looks if the Constitution is violated or not. They don't take decisions with regard to what we call simple law. And just give me 1 minute. And the problem with all these different jurisdictions from different district courts is that normally for a real case, if there's a sentence, then you have the high court. You start at, for example, at the regional court, then the court district, and then you go to the high court. For cases like that, with regard to the raid or confiscation, the district court, after that it's finished. It never goes to the high court. That is the reason why we have in different cities different protection of the legal privilege.
So Harsh and Holly, first Harsh and then Holly. How has something like you've learned about Jones Day case, how has that affected your approach in a big international company like J.P. Morgan?
So when we think, I mean, I wish I could tell you we've come up with a perfect solution, but we haven't. So I think what we do as a U.S. company is first think about our U.S. concerns and then extrapolate out. So while the German events are new in that they're raids of law firms, it fits largely consistent with what we're trying to do globally. And it'll come as no surprise. What we try to do is write less, document less, and make sure that there's not stray emails and things like that. It's all easier said than done because there's almost no way to communicate with people across multiple time zones and across multiple businesses and given time, schedule, etc., than to write these things. But what we try to do is a kind of pronged approach where we say, write as little as possible until you're clear you're doing a review. When you get that point, set out who the client is, what we're doing, what the scope of our review is, and then you try to maintain privilege. But the fact is, when you're rating law firms and your advisors, I'm not sure how you have great comfort that you can protect all that privilege.
Do you feel protected as an in-house lawyer?
No, I mean, I think people here will recognize that even within Europe, there are various regimes. If you're sitting in Switzerland, you have to have, Swiss counsel has privilege, but not other counsel. If you're sitting against the EC, you need European counsel to advise you. And so on antitrust matters, we'll bring in counsel probably a little sooner than we normally would. But you're kind of on that sliding scale. And even after ENRC, you're not really sure who your client is. And I think the most helpful bit of that opinion is the court's sort of instruction to future courts that they need to modernize this part of the law, which they do. It doesn't work that you can speak to 5 people who are senior but not their direct reports and it can skew out. So it's a long way of saying we're not really comfortable outside the U.S.
And the real lesson here is it your experience, and I'll ask the whole panel, that when you venture into another country, that one of the things you have to understand, whether it's trying to figure out what an accused is in Germany or what the situation is in Switzerland, what is the privileged situation? Do y'all all do that? Starting with Holly.
Sure. The answer is yes. I think on the day that the Jones Day, the first raid, was announced, I was working on a cross-border investigation that involved a client headquartered in France but listed in the United States. And it involved an investigation in Asia, Africa, and the Middle East, and probably had 2 roomfuls of work product sitting in the Wiles Paris office. And it struck fear in my heart to read that article that the office was being raided for work product documents, not for some crime that had been committed by the law firm. And immediately there were people on my team researching French law on the subject. You can't always get sort of 100% basically sure that you have protection there, but that's when you start thinking about are there solutions, are there technology type solutions that where things can be stored in the cloud, so they're not physically sitting in the Paris office or in the Munich office. But I think, as Harsh said, it's hard to get 100% sure, 100% comfortable. It is also not practical to not write down the notes from 250 interviews. So it's got to be written down somewhere for you to summarize it later and for you to report it to your client first, and then usually to report the results of your internal investigation to, in our case, U.S. government regulators. So the ethical considerations here are that basically the requirement for most U.S. lawyers is going to be that you did something reasonable to prevent waiver. You did something reasonable to prevent disclosure. If you now have knowledge that in Munich, at least, and maybe not Stuttgart or some other district, but in Munich, that if your documents are being kept at an international office of a U.S. law firm and they are work product documents, that they may be subject to seizure and privilege waiver. And if you're aware of that, then it's not reasonable, probably, to keep those documents stored in that location. So it's really this sort of reasonableness standard that you have to abide by, but you also have to do something that's practical and cost effective for your client.
So Jim, are there, what suggestions, from this experience do you have for lawyers that are engaged in internal investigations in the cross-border space?
What Harsh said, kind of, but I'll expand on that a little bit. What Holly said too. I mean, we're you're very, very clear in your engagement letter that regardless of who you're representing, you are gathering facts for the purpose of rendering legal advice.
Mm-hmm.
I mean, these are things that we frankly did. We think we ran up against a particularly challenging court. Very clear messaging when you're cooperating in real time with the authorities that you're not waiving any privilege. You've asked us, our clients directed us to cooperate real time and tell you what we're learning, but we're not waiving the privilege. Because we are going to talk to our client about some things that you have no right to know. You have no right to understand those things unless our client tells you otherwise. And then the things you talked about in terms of data storage and using remote servers and keeping documents a certain place. And everybody needs to just be far more judicious than they think they're being in using emails back and forth.
When you go to a foreign country from the United States, is the idea should one be using local lawyers from that country to do the internal investigation,
sure.
and would that make a difference?
I'm not sure it helps. If you look at here, there was the RBS rights issue case, right? The interview notes and the interviewers were in the U.S., and those were pulled in. So when you have that kind of overlay where you're looking at where the facts are, where the events are, and you can't use U.S. lawyers or put documents away, it even calls into question the cloud or how we would store these documents. I think the best advice you can do is be judicious about this. Think about being very clear up front to set out what you expect the privilege to be. There's things that we've seen, BCI, bank confidential information. It's not a concept that's recognized here, and it's even been chipped away at in Germany. But we, during raids, are always raising that and going, it's not even our privilege. And so we will get our prudential regulators involved and say, you can raid this, you're taking their documents, you can pick a fight with the OCC or the Fed if you want. But here are the issues. But again, if the information is seizable in their country, they're likely going to seize it.
Sandy, there's an element of this too that's because there have been raids of a number of law firms in Germany. We don't mention the other ones because for some reason.
We can mention the other. We can mention.
No, but it happens to other folks. But I don't want to speak about our case specifically because I have to be very, very careful. But if you study what's going on in the other matters, and there's something that's even in that ENRC thing, there's an element in those matters, and this is what's beyond the outside counsel's control. There's an element that appears to be in these matters where the prosecutors have at some point in time grown unhappy with the level of cooperation from the company, from the client. So when we're raided, hypothetically that same day, they also raided our client. So as opposed to saying, we want to engage in you and have you bring these things. If the prosecutor gets a different idea whether the client is being willing to cooperate, they say, well, we can't just ask the lawyers for stuff because the clients will tell them no, right? And they'll follow their client's instructions. So that element is very much, I think, a little bit not entirely within the control of the outside counsel to assess. But I see that in a number of these different matters. You know, prosecutors not real happy with. I mean, in the SFO case, I thought they actually just sort of changed their mind and stopped cooperating at some point.
Right, and Simon will address that in a minute. But just to make sure that Jones Day is not out there by themselves. I mean, there was recently in Germany, arising out of this, Bjorn, a search in Porsche. And the search warrant, the first section of the search warrant specifically authorized the investigators to take out the general counsel's office. And they set the general counsel on the sidewalk and her staff, and they pretty much seized everything in the general counsel's office, right?
Yeah, that's right.
You know, and so it doesn't make you feel better, I suppose.
No,
Harsh.
but that's sort of the world we've been living in for a while, right? It doesn't make me feel better. It makes it so I'm really good about cleaning out my inbox, right? And storing things and not having stray emails. But you know, that's how competition dawn raids also work. They come in, plop down in front of your computer, and start reading.
So Simon, this time last year, at this conference, we were lamenting the fact that in the ENRC case, that the High Court had allowed an SFO subpoena for the production of what was seized in the Jones Day case, but was the work product, the internal investigation of Deckard arising from a bribery investigation. Now that was referred to by Lisa this morning, a very recent decision. So why don't you address that? Tell us what the state of the attorney-client work product privilege here is in the UK now.
Well, I think the first observation to make is that the decision that you were looking at last year has been reversed by the Court of Appeal last month, about a month ago. So the decision you were concerned about is no longer the decision that you need to be concerned about. All of the trial judge's findings as to the nature of the documents seized were largely overturned on appeal. She got both the law and the application of the facts to the law wrong. I think the second observation to make is this wasn't a situation like those that you've been contemplating so far this morning. This was the service of a production order under the Criminal Justice Act, so it wasn't a search warrant involving a raid, even though the General Counsel and other officers of the company were concerned about the risk of dawn raid. So this was a facility where on notice the SFO were able to serve a requirement that certain documents be disclosed, and in response ENRC had the right to be heard by a judge as to whether LPP applied to some of those documents or not. Look, as a decision itself, it's neither, to quote Melville, neither a caterpillar nor a butterfly. It doesn't really take the law much further. The one critical decision it could have attempted to evolve was the extent of legal advice privilege in this jurisdiction at least, but it declined to do so. So in relation to the litigation privilege, the critical decisions that it began to explore were dominant purpose. So, and again, that's relevant to a lot of the discussion we've had this morning. It's not really about your communications per se, but the purpose of your communications. And if it's capable of being demonstrated that the dominant purpose is to either prepare for or take advice about litigation that's contemplated, then that's significant. And that's likely to lead to an embargo on that material being seized. And then the nature of the inquiry. And one of the big issues in the ENCR case was whether it was about compliance or an ongoing investigation. And the Court of Appeal using their words, said that that needed to be unpacked. And it considered compliance to be directly causal to governance, and governance was the stick with which companies complied, and therefore very often compliance will constitute criminal investigation, albeit from a deterrent point of view. And in that respect, the Court of Appeal here made a decision that was ultimately favourable to the company. So as a case, I think it's something that folks can probably relax about. The position in the UK remains that in terms of overt investigations, you cannot, there is a complete and also embargo on the authorities seizing material, not seizing, having access to material that's covered by LPP. They may seize it, but if there's a risk that they're going to seize it, they have to have a team in place, including so-called independent counsel. I mean, it's only independent counsel in parenthesis, because very often those independent counsel are appointed by the investigators from barristers' chambers, which they frequently use. So it's not independence in the sense that we might understand it more generally. What's more worrying, it's a point that was made earlier on about the German system and there being a complete estoppel on the German authorities using surveillance against lawyers in that jurisdiction. Here, under the Investigatory Powers Act, lawyers can be surveilled. It's that simple. You have to have special authority to do it, but there's no grounds particularly need to be established, providing it's on one of the grounds set out in the Act. So that could be generically prevention, detection, serious crime, national security. But once the grounds are made out, the only test then is whether the authorities think it's necessary and proportionate. So in overt policing, you're protected. Covert policing, it's a free-for-all. None of that affects admissibility. The position in the UK remains that no LPP material is of itself admissible.
So, did you have something to say, Jim? No.
No,
Okay.
I guess not. Yeah.
So, Holly,
Maybe I do want to add one finer point, just a little bit. I'm sorry, because before we completely, a parallel between the case you just talked about and the other matters is this idea that the law firms initially were cooperating, and then at some level there was a dissatisfaction in that, which led to the aggressive action by the prosecutors, which strikes me as just completely bizarre. Because if the law firms were like, we're not cooperating, we're just defending this company, we'll see you in court. Those law firms in those settings don't appear to be subject to raids. It's a bizarre thing, which I think sort of disincentivizes or makes people think twice about cooperation at some time. And in our matter, and then I'll shut up, Sandy, I will, I promise. But in our matter, we, Jones-Dale, it's a finer point that may help you understand, we didn't represent the company in negotiating with the authorities. We were the special counsel for it's like being a counsel for the board to do an investigation. They had separate lawyers defending the company on the exposures in the United States and in Germany. And those were the law firms that would be cooperate. We would just show up and tell the authorities whatever those lawyers would tell us to tell them. Those law firms do not get raided. They did not, and appropriately, but we did because of our different role. But anyways.
well, I'll tell you, in the Porsche search warrant, the search warrant itself directed the authorities to look for King and Spalding, because King and Spalding was so I'm factoring in King and Spalding now, so it should make you feel better. King and Spalding was Porsche's firm that had done internal investigation type stuff, and so the warrant itself, right, Bjorn, specifically addressed King and Spalding materials that the company general counsel would have had on premises. So, there you go. Has this had a chilling effect, something like the Jones Day case? Has this had a chilling effect, Harsh, with regard to your communications with outside counsel and how you go about doing that?
Somewhat. I mean, I think I say somewhat because we've always had that overlay of concern in different jurisdictions about the disclosure if we hold it on our books. But it just makes the sort of discipline and sort of documentation hygiene concern higher.
So Holly, what are the implications of, so in Germany, let's say, this privileged information or whatever country is seized, what are the ability of prosecutors in other jurisdictions to use that information that has been seized?
Sure. I mean, this is the concern if you have a cross-border investigation that includes the U.S. government regulators, that they will now be able to use privileged information that's been seized in another jurisdiction. I think that what we have to consider are just several different arguments to make and considerations, some of them strategic, in your investigation and your representation of the company as they try to resolve the issues. I mean, the first argument that I would look to is, can the company argue that the search was not proper? This is now whether U.S. regulators can use the information in a U.S. criminal proceeding. And whether that search was proper under the Fourth Amendment, and if not, therefore, could you exclude it? There's a case out of the Second Circuit, U.S. versus Lee, that says that under sort of normal circumstances, it's the silver platter doctrine. It's followed by many other circuits as well. Basically says evidence that's seized in foreign jurisdictions in violation of the Fourth Amendment can be used in a U.S. criminal proceeding. Unless, and here's the important part for your argument, unless the foreign governmental entity was acting as an agent for the U.S. government or acting in tandem with the U.S. government. That's what you'll have to be able to prove in order to exclude that evidence. As we've heard this morning earlier, and as we've heard probably for the last year or two, a high priority of U.S. government regulators is international cooperation. And so we talked about it they talked about it on the panel this morning. So that's something that you're going to want to look into. On sort of a related but not or tangential note, there is a recent case also out of the Second Circuit, the Allen case, not directly on point because that case involved the Fifth Amendment against self-incrimination. It was very careful to say that that case only applies in Fifth Amendment cases. But basically in that case, the court found that you could exclude basically testimony that was compelled in violation of the Fifth Amendment in a foreign jurisdiction. So that was an area in which you could exclude certain testimony. I mean, the second argument after, whether the search was proper and could it be excluded under Fourth Amendment grounds would be, I would just argue again that it's privileged information. It was not waived. There was not a voluntary waiver by the seizure. And that if you're dealing with U.S. regulators, their normal policy will be to institute a taint team and to review those. We heard this morning again, the U.S. government cannot demand that you waive privilege. But often the third consideration here is, do you need to waive in order to get cooperation credit? Cooperation credit is very important. However, it has to be balanced against the fact that that waiver that you're offering in order to get the cooperation government could allow discovery of that information and follow-on civil actions. So those are the considerations in terms of those type of seizures.
And in Germany, if the anticipation, the belief is if they come in and seize all this stuff that the Americans think is privileged but is determined not to be privileged, that it can be used?
No, it can.
In Germany?
In Germany, yeah.
Germany.
It depends. It can be used because we have a very, you mentioned there another complicated topic, so-called admissibility of evidence. And in Germany, we have in principle, all evidences could be used if it's not specially forbidden to use them. So we have Even you can use evidences if they are created, if the base is a crime. For example, it's forbidden for a private person to tap a phone call, but we have jurisdiction saying that you can use it at the criminal court. You can use it. There's a difference between civil and criminal procedure. I think I cannot talk about civil procedures, but even in criminal procedures, you can base a sentence on an evidence that is created itself by crime. So the fact that something is forbidden or not under another jurisdiction does not forbid to use it for a court, to use it as an evidence. So there are other conditions if we have, for example, a special amnesty request and there is a treaty between some states, but normally a German prosecutor can use any evidence that might be privileged under another jurisdiction.
Okay. So Harsh.
I mean, that's what they do in the diesel case.
With regard to internal investigations for a company like yours, do you go into the investigation now with the expectation that this information is probably not going to continue to be privileged? I mean, is that the way you?
No, we fully. I mean, we will defend our privilege to the hilt, right? And I think we have to do that. In the vast majority of cases, right, we're not getting raided. Our law firms are not getting raided. We have these arguments, and I think the lawyers on the other side are willing to listen because at its core, this is an argument about why we do what we do, giving legal advice to clients, right? And so what we try to do is set ourselves up for the best possible way to have that discussion with the other side, which in most circumstances works. Sometimes there's a shifting scale, and I think in the last panel they talked about how, the DOJ won't ask for these hypotheticals because it's not valuable, and, the Florida case kind of cuts whether that is even viable anymore as a waiver of privilege. But what we're finding in practice is at lower levels, this practice continues where we're being asked, well, give us this information, you can do it in hypothetical, there are ways to do it. And I think what we try to do is set out the parameters of our claim of privilege and then ask whoever's asking us to waive it to say so. And then we can have a discussion, because if you're asking us to waive privilege, then we can have a discussion about that.
Okay. So sort of, if you look at it as sort of a scale, and take the Jones Day case as, in Germany as sort of an indication. Is there, if it's just a relatively small matter, you have big matters and small matters, right, Harsh? Mm-hmm. If it's a relatively small matter with no current government involvement, is there any real concern in a matter like that? And everybody can mention this as to whether, the privilege is going to be assaulted by the government. Is there any real concern about that?
Probably less, right? But the concern is it spreads out. A lot of these smaller things you think as an isolated trader doing X, Y, and Z turns out to be a lot wider. We just never really know. There's always follow-on civil risk. It's increasingly a risk that we're taking into account here in Europe, but it's less so. But there'll probably be less documentation for those ones as well.
So Jim, but what if it's a big case like VW and the government's already involved and there's a major investigation going on? Should the lawyers in a situation like that, where the government's already investigating, be more concerned about the challenge to the privilege?
Yeah, generally it should be at a higher level of concern in terms of your list of things to care about in the case. But in a lot of those bigger cases, you're being directed by a very sophisticated in-house legal counsel who is telling you certain things that sort of then will put that on a certain path. If you're saying to me, we're representing you, we have the government's looking at us, but we've acknowledged we have a problem. We want you to cooperate in real time with the government and tell them all these things at that point in time. There, you're just very clear when you're telling the government what you're telling them, what you're also not waiving. But a lot of that's driven by Harsh. You know, like what is the client telling you how the right approach is? And if the client's saying we didn't do this, and you know, we're going to defend, and if they want to talk to our people, we'll get them lawyers, we'll do all these things. The odd thing, based on this record that we've seen so far, is that diminishes significantly the likelihood that someone's going to come after us, raid our office, and say that you know your information is available to us. If you take a firmer, harsh, we didn't do it approach, it's easier to protect the information, which I think is kind of in my view, that's an oddity.
Did you all even go through the process of saying, hey, we checked all the boxes? You know, we checked all the boxes. We explained to the employees that that we were representing the company and we were doing this in order to give legal advice to the company. I mean, did you even have an opportunity to sort of explain all that?
We had a very fulsome explanation of how we did internal investigations 101 the right way, with the upjohn warnings to all the employees, who we represented, how we were gathering facts so our client could give legal advice, all those things. It all didn't really matter ultimately to the Munich prosecutor. And again, I'll speak now hypothetically,
right.
So I would say step outside the case. At some level, though, hypothetically, what likely happened was the prosecutor was getting impatient with or uncomfortable with the level of cooperation that the advocates for the company was giving at some point in time, which I think was present in the NRC case, right? And then that led the prosecutor to take a more aggressive action. So, yeah.
And is there anything that, looking back on it, that the firm or the company could have done that they didn't do, in your view?
I can't answer for the company. I can't answer for the company because I think that involves a dialogue that I don't want to discuss.
The firm?
The firm, no. I mean, I'm apologizing to no one about the way we handled things and stored documents and did the work. It made sense to do it with our German colleagues because they're brilliant, good lawyers and who suffered this incredible moment of three really good people. Martin Koch and Michael Mayer and Thomas Berg got raided. We did it the right way. I'm convinced we protected things the right way. I think going forward, there are some things we might do about like using a different server and maybe carrying hard document or not having hard documents printed in a certain office. But that doesn't mean we did anything wrong.
Bjorn, is there anything that going forward that a firm can do to avoid this?
The problem is that the Constitutional Court didn't really decide this problem. So I have a little bit hope we have there will be a change of law within short time. That's what we think. There will be a new criminal corporate law, and the legislator have to really to decide these questions because as I told you, on one hand they want these internal investigations, and on the other side things are not very clear for law firms. There might be, and this when you read the first comments with regard to the Jones Day decisions, there are some articles and proposing some dodgy ways, what I call dodgy ways. You put all the information outside of Germany, but what is this for law firm to hide things? Because when Jones Day did this internal investigations, you made it to disclose things, and then on the other side, really to protect your informations, you have to take them to carry them out of the German area, probably in a cloud. That's one thing. You can put it in a cloud and protect your server. But this is not the solution that I wish for really a disclosure. I mean, if I was prosecutor, I don't think that perhaps in this case the prosecutor of Munich they won a lot of informations, but for the future, if there's no change of our legal system, it would be the opposite. It would it would be an undisclosure for the future, because if you are a company and you take a big law firm like Jones Day or other ones to make an internal investigation, you cannot guarantee the protection neither for the company nor for the individuals. This is something that we didn't discuss, but it's also for the individuals, the people that were interrogated. I mean, if they have no protection for the results of the interviews, this is another big problem.
Yeah, there was something. This is such a different case, Sandy. And there's ways to look at it where you can be less alarmed about it, signaling that it's going to happen to everybody and happen often. This is an iconic German company. It's this case is in the paper every second, and it's a big, huge deal. And there's a lot of pressure on, and I don't want to, on prosecutors and things to try to make things happen. It was also part, and this is of record, of the settlement with the United States government, the plea. Volkswagen had to admit that there was obstruction of justice in connection with the matter in the United States. And there were document destruction and some really very, very poor decisions that were made by some people once it was clear that they were being investigated in the U.S. And so they had to eat that charge. And right there, you could certainly envision a local prosecutor at some point now being very cynical about certain things if that's admitted as he or she is investigating. I'm not trying to bail the guy out, but I don't know why he rated us still. But you could see that added to a level of cynicism, and it was a unique factor. And if you didn't have that, and you didn't have the size of the case, you didn't have certain other things, I think you can be far more comfortable that this rare occurrence is something that you're not going to have to deal with on a regular basis.
So let's switch the topics. We have about 15 minutes, and I really would like to leave a few minutes, for some questions. But there's another issue that has been occurring in the United States, and that is searches at the border. In the United States, I'm going to short circuit this a little bit, so I apologize, panel. But the United States, there is an exception to the Fourth Amendment that basically allows border searches without any probable cause or reasonable suspicion or anything like that. If you cross the border, customs can search. And in the old days, they could look at your purse or your suitcase, but now we have these devices, these digital devices that have, just tens of millions of all kinds of material, privileged and otherwise, in it. And so we have had an uptick in border searches of digital equipment, and it's created some real issues for lawyers and their clients that practice in the international sphere, to the point that this past winter, the American Bar Association, we're here in London, but we also had our mid-year meeting last year in Vancouver, Canada. And before the meeting, everybody coming to the meeting got a memo from the American Bar Association warning us about cross-border searches and how we could protect our privileged information. So, Jim and then Holly, can y'all address that and address what lawyers can do, and if it's appropriate, like some people are being advised to travel with what we call burner phones or clean devices and the like, because it is a issue. And then I'm going to have Simon talk about the ethical considerations for lawyers when they do take these proactive measures.
Holly, why don't you?
Sure.
Yeah. I'll chime in.
Basically, in January of 2018, Customs and Border Patrol, which is the regulator at the border, issued a directive, and Sandy's described some of the factors in that directive. But there is a specific section that deals with privileged information. And what's been happening are, everyone's being stopped at the border and their devices being searched, and so that would include attorneys. And what should you do at that point? If there is an assertion of privilege, that there's privileged information on your electronic device, there are certain procedures that the Customs and Border Patrol are supposed to follow, which includes contacting the Chief Counsel's office assigned to Customs and Border Patrol, and the possibility of a filter team, sort of a taint team, to review information. I think that, looking at how this impacts you if you have, sort of privileged information on your electronic device, which you probably do. I know I have, I know there's privileged emails on this device. I think that, and also there's a directive by ICE, which is the Immigration and Customs Enforcement, which is a little different and has been in existence a little bit longer. But I think that the practical takeaways, here are under U.S. ethical considerations, you must make reasonable efforts to prevent disclosure. So now you've reached the border, and when you were talking about this, Sandy, you sort of asked us, what are you doing? You're traveling for an investigation. You have this information. You might.
Yeah,
have
I know what I do in Germany now. Seriously.
Yeah.
I bring a burner phone and a tablet that doesn't have anything on it, and then I, access the cloud. That's what I do. I didn't do that in London, so you may tell me I've breached some kind of ethical responsibility.
No, and actually, New York has come out with an opinion, an ethics opinion, that basically follows sort of these same parameters. But before you get to the border, you should consider what information is on your electronic devices, whether it's necessary for the particular trip. One thing I do is I really don't travel with a laptop. What I do is I access a laptop wherever I'm going, and then access the information from a network or a server or the cloud. And so then I'm not at the border with my laptop that can be searched. But obviously I travel with my phone, which does have at least emails and that type of information on it. So, and often it's just not practical or cost effective if you're going out to conduct the interviews for your investigation to not have a device with information on it. If you're searched and there's a request to, look at your device, I'd identify myself as an attorney first. And I'd have identification for myself as an attorney to demonstrate that. And then I would communicate that there's attorney-client information on the device, and I would make a specific request not to inspect the device for that reason. Not that my request is going to be honored, but the request is going to be made.
I just denied the request, and
Right.
I want your passcode
Exactly.
so that I can open your phone.
And then that if you've asked, usually that's going to require a demand that they inspect your device, not a request, a demand. And that's what I would try to get out of that officer. I also would try in some way to record that conversation or how that interaction happens. Often, you're not allowed to use your phone because they're trying to take it. But I would try to have some sort of witness or recording of that exchange. And then I'd ask for Customs and Border Control to follow the instructions that are required by the directive that came out in January to contact the counsel's office and to follow those instructions. Also, after that, consider you need to notify your client that this has occurred. And I think that probably those are reasonable steps to take to prevent disclosure. One of the real things I have to look at in this directive is that it does not require consent of the individual. So they can search your device without your consent, and they also don't need reasonable suspicion or warrant or probable cause.
But if you won't open the phone, in other words, if most of us have some sort of security code or passcode.
Right.
I've had the general counsel of Homeland Security on panels before. They'll just take the phone. They won't keep it forever, but they'll take the phone, and if they think it's necessary. So, you have to make a decision. Is it an ethical violation, Jim or Simon, to make the decision to open the phone? Is that a problem if you're concerned?
Yeah,
Providing there's lawful authority, whatever that lawful authority might be, and in terms of the border, that's likely to be under the auspices of national security. And in this jurisdiction, there'll be either a specific or general authority under the Investigatory Powers Act or some other legislation. Then no. I'd go so far as to say, contrary to the position in the United States, that no burden or duty can be imposed on the lawyer to take any steps to avoid that from happening, and providing there's lawful authority for it. In this country, insofar as there's been any formal guidance, it's been issued off the back of the American Bar Association advice. It was a short article published in the Law Society Gazette by a former council member, who pretty much said, you know, if they attempt to access your password, you should enter it manually. You should expressly state that the nature of the material is likely to include LPP, and you shouldn't enter an incorrect password or give them an incorrect password. Incidentally, if you do that, it's a criminal offence here. And if you refuse to enter the password, they can serve you with a decryption notice requiring you to do so. And if you don't do that, you can be prosecuted. And that offence carries an increased sentence now, I think, of 5 years imprisonment. So the sanctions can be pretty severe.
At a U.S. border, though, I mean, American lawyer at a U.S. border, if I had done everything that Holly suggested and they said, we need your I said, you would just say no. And you would do that with some reasonable comfort that they're not going to keep you. They might keep the phone. And you would live to have an argument about that another day. We have...
But if you said yes, if you said, sure, you can have my passcode, do you believe that that's an ethical violation?
Yeah, I mean, I can't peg it to a rule, but yeah, I think that I'm doing something I don't have to do. I'm sharing a client confidence in a setting where I really am not. There's no compulsion by a court at that point in time. If it was a court order compulsion, it'd be different. And we haven't had, and maybe Holly can correct me or somebody correct me, we haven't had horrible decisions about attorney information at the border in the U.S. That we have, if you like the Fourth Amendment and you're a fan of that, the bad decisions we have about no probable cause, no reasonable suspicion needed for property, you know, we get a lot of bad decisions, and we have some what I would consider to be some bad case law, because, you know, there have been some cases with some really, really bad facts. I mean, the guy crossing the border, the case out of the 11th Circuit just now was a guy crossing the border with child pornography, right? And you know, and we all, if anybody's defended people, know that bad facts for one defendant can lead to bad law for a lot of the rest of us to deal with for a later time. But we don't have, I'm not aware of, Sandy, maybe you are, of a case about attorney privilege at the U.S.
No, I mean, it's really interesting. I mean,
yeah.
the Fourth Amendment cases are in transition, even with the Supreme Court in the United States, everybody's been reading about it, you know, getting, you know, certainly a conservative bent to it. It turns out that the Chief Justice, who's pretty conservative as he is, he has participated in several decisions in the last few years that have addressed this the digital age and digital issues, and have reined in the prosecutors as it relates to the seizure of cell phones and looking at without warrants. So the question is whether they will address what has been a right without any probable cause of suspicion to search at the border as it relates to digital equipment. And we don't know, but they certainly seem to be in that direction. Well, that's it.
No one wants to hire us now? Come on.
It's a great law firm, is all I can say. Thank you very much.